Request you to play ICI Moto song.
य एष सुप्तेषु जाग्रति य एष सुप्तेषु जाग्रति कामं 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 कामपुरुषो पुरुषो निर्विमाणः निर्विमाणः तदेव शुक्लं तद्ब्रह्मा तद्ब्रह्मा तदेवामृतमुच्यते तस्मिन् लोकः शतः सर्वे तदूनात्यपि कश्चन एतद्वैता 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 एतद्वैता.
Good evening, all. Welcome to this session on Code of Ethics, where, under the leadership of our chairman, CA Saurabh Ajmera ji, we all are striving for the professional excellence, and it can be achieved only when we cultivated an art of ethics as well. So, with these words, now we are welcoming our chairman of the largest region, CA Saurabh Ajmera sir, to have opening remarks. Over to you, sir.
Thank you, Vishen Bhai, the Dynamic Secretary of WRC, CA Rakesh Shah, again Treasurer of WRC and versatile personality, I can say, and all the participants and the faculty of today's CACN Vaze sir. Thank you, sir, for accepting our invitation on such a short notice.
It's my pleasure.
Friends, this year we are targeting to have more and more programs to empower all our members in a different way, where we can excel for our professional growth. And friends, in this series, today I welcome you all in this another exciting program on amendment in Code of Ethics, where we have to understand what are the ethical practices we have to implement in our working and how we can do something better in our profession through following of the Code of Ethics. And friends, this year we are targeting to have an impact on each and every members through our initiatives at WRC. In this series, we have come out with so many initiatives. I just want to highlight two major initiatives in this virtual program, that is CA Nexus and WRC Corporate Setu. First, I will talk about CA Nexus. Friends, as we all know that we are in the era where we have to synergize our energy and we have to build a collaboration amongst all the partnership firms. And that is why we have come out with CA Nexus, where we are targeting to have collaboration with the smaller firms to get them in on a larger platform. That is why we are inviting database from all the proprietorship firms to have a collaboration with larger firms in this CA Nexus initiatives. And then friends, one problem statement we all were feeling from the days when we have joined as a student for this profession, that is our industry member is not connected in an effective way with WRC or ICI, I can say. And that is why we have come out with WRC Corporate Setu, again a very wonderful initiative where we are targeting to have a footprint from all the members, those are working in industry and businesses. So we can also have a great opportunity to interact with them, and they can also be the part of our mother institute in an effective way, where they can also feel proud that what type of work we are doing. And friends, believe me, when we are saying to have an impact on each and every member, each and every stakeholders, we are starting with I, because in life also we are starting with I. So I stand for innovation, where we are driving a lot of ideas for our members. Specifically, we are doing startup programs, we are doing DPDP Act programs, and all the new areas where we can innovate our members to have something new in their day-to-day life in their professional life also. Then M stand for mindset, which is again very important. Whenever we are going for any new role, the mindset should be positive and the mindset should be growth oriented. As we all know that India is a now global growth engine and there are a lot of opportunities. So we are promoting all our members to change their mindset and we are promoting go global practices in this mindset part. And friends, as we are in the program of code of ethics and we always say that ki professional excellence is a thing which we have to understand, and that is why in impact also P is the core, where we are saying that we are the part of ICI where all the stakeholder is expecting to have a professional excellence at a very good level. And then A stand for adaptability, which is again a core of this thing, because 2 years back, if I talk about the AI, we were not using AI in a very keen way, that way we are using in current time. So adaptability is a thing we have to be openness, and we invite all the new initiatives in our day-to-day working. Then only the implementation which we are expecting from our members can be determined. Friends, C stand for collaboration, which is core of this thing, I can say, because whenever we are having opportunity of networking, we always strive for collaboration, and collaboration can lead to have a major impact or long lasting impact which we are trying to have on our fraternity. Requesting all the members do participate in all programs, do some collaboration, which is again a very important part of our profession. T stand for transformation. We all know that our country is flourishing very fast. We have seen a journey from 1 trillion to 4.3 trillion US dollar economy size. We are heading towards 10 trillion US dollar economy size very soon. But are we taking participation in that journey? That is very, very important. That is why we are saying, let's transform with nation where we are the principal stakeholders. We can have a very effective participation in the growth of economy. Friends, all our initiatives are available on WRC website. Our secretary, vice chairman, and treasurer definitely will guide that how you can take benefit from all the initiative. My request to each and every member, please be participative in all the program of WRC to take maximum benefit, because we are known for the impact part which we are trying our level best to provide to all our members. With this, once again, I like to hand over to CA Bishan Shah, Secretary of WRC, and I want to recognize the presence of CA Rikin Patel, Vice Chairman of WRC.
Thank you very much, sir. And it is always said from your talk that integrity is not optional, it's a profession. What you have inculcated, and in your vision, we can able to see it. A true leader who knows the way, who goes the way, and who shows the way. So thank you very much, Chairman, sir, for those words of wisdom and opening remarks. Now I request Treasurer of the WRC, CA Rakesh Shahji, to give an introduction of our learned speaker and experienced senior member, CA CN Vaze, sir. Over to you, Rakesh bhai.
Thank you, Bishan Bhai. So I'm here to introduce, as Bishan Bhai said, I'm here to introduce CACN Vaji sir. So Mr. Vaji is a seasoned and senior chartered accountant based in Mumbai with more than 40 years of experience. He is considered to be an expert in the area where he is talking today. Is also is having deep interest in mythology, and he has delivered lectures and written articles on Valmiki, Ramayana, Mahabharata, Bhagavad Gita, and many other social subjects. He delivered lectures and written article on taxation, banking, allied subject. As I said, he is also considered to be expert on code of ethics for CA. Is also recipient of Yoga Mitra Award from Yoga Vidya Niketan, Vasi, Navi Mumbai. Is also recipient of Best Social Worker Award from Senior Citizen Association, Malone. recipient of Jal Dastur Award for Best Features in the BCA Journal. So, welcome, Mr. C.N. Vaje. Over to you. Thank you very much.
Yes, sir. Before sir starts, we have our vice chairman of the region, C. Rikin Patel ji, and I request him to formally welcome CN Vaje sir for the webinar. Please, over to you, Rikin bhai.
Good evening, everyone. And I think uh, amendment in Code of Ethics was much needed, and it is going to amend from 1/4/26. And I think we already have a session before even implementation of that amendment. So I think it is a great thought, and we have our expert faculty in form of CN Vaze sir. So I think it is going to be a very interesting session, and I think everyone will learn a lot about Code of Ethics. So I think with that words, I welcome Vaze sir, and I request him, I think, to take charge of the session.
Yes, Rikin bhai, thank you so much. And what we want to know that chodo kal ki baat purani. So Vaje sir's insight on the topic will definitely more impactful for the members. Over to you, Vaje sir. Welcome.
Namaskar and good evening to all of you. So let
Namaskar,
me
sir.
first, namaskar. Let me first share the screen so that I'll go by the PPT. But I must compliment all the office bearers of WIRC for being so proactive that actually this is going to be implemented, as you rightly said, that it is to be implemented from 1st of April 26. But before that only, we have organized this kind of lecture thanks to Mr. Saurabh Ajmera, the dynamic chairman of the WIRC, and then also the other office bearers, Mr. Bishan Shah, Mr. Rakesh Shah, and Rikin Patel ji. Friends, let me clarify one thing at the outset, that when Saurabh called me and he said that the topic is focused on the amendments in the Code of Ethics or the revised Code of Ethics. Yes, it's a fact that the revised Code of Ethics is going to be implemented from 1st of April. But let me clarify that there are still certain issues which are yet to be resolved, and therefore I was officially told by the Institute of Chartered Accountants of India, our ESB, Ethical Standards Board, that the relevant book has not been released. So what I have with me, what were the changes which were proposed, and I'll just give the highlights, because then that is the reason I could not prepare a separate PPT, because most rather the new things are yet in the offing, in the sense it is yet to be released. So let those issues be resolved, and therefore I thought that it is not prudent and wise to share the PPT, because otherwise the members will be misled by that. Nevertheless, whatever I have with me, the proposed changes which were there, which I have not included in the PPT, but still I will just highlight them because it is also necessary, and all of us will appreciate that many people are not even aware as to what the present code of ethics is. So unless we know what is the present code of ethics, we cannot appreciate the changes. But that apart, let me mention a few highlights of the this revision. The first and foremost thing, this is not covered in the PPT for the reason I just mentioned to you, but just to give a highlight or a glimpse of what are the areas in which the amendments have been done. See, basically, Code of Ethics is now governed obviously by our Chartered Accountants Act 1949, and there were major amendments in the year 2006. So the entire procedure, entire concept have been changed. Let me also mention that many people are confused with the title Code of Ethics and Code of Conduct. Many people mention it loosely as Code of Conduct, and many people mention it as both Code of Conduct and Code of Ethics. So let me clarify a very fundamental thing, that earlier these principles were also called Code of Conduct only as a generic, because everywhere you will find a Code of Conduct is a common expression. But in the year 2000 or thereabout, our institute consciously thought that conduct is a very generic term, and conduct will be good or bad. Whereas ethics essentially denotes a positive term, and there is no such thing as good ethics and bad ethics. Either there are ethics or there is absence of ethics. In short, the first principle is that you are either ethical or unethical. There is no in between way. So that one has to keep in mind that you have to be ethical, and if you compromise on ethics, then you are totally unethical. Now, with this clarification, let me go ahead. So, in the Code of Ethics, basically, friends, there are 3 volumes at moment. There are 3 volumes means first volume is based on the ESBA, that is International Ethical Standards Board, whatever are their core ethical standards. Based on that, which have been a little adapted for the Indian circumstances, that is volume 1, which is already there. The revised volume 1 is yet to be released. Now, volume 2, as of today, has the regulatory or the statutory part. That means the CA Act, what are the provisions of the Act, rules, regulation, guidelines. All this is covered in the volume 2. And volume 3 contains the case laws. Now, there is a major structural change in these volumes. The old books are available, the new books have not yet come. Now, in volume 1, which are basically the principles or the philosophy, that means the independent standards and such things. So, where in volume 1, there are as many as 18 changes which were proposed. How many of them have been fully endorsed? That I am not aware, because that we'll come to know only when the book is released. Volume 2, there are 16 changes, and volume 3, there are 6 changes. So, all told, there are about 40 changes which were made. Now, I'll quickly go through the highlights. And volume 3, now they have reshuffled it, restructured it. That will come separately, but let me mention here that volume 1 remains the same as the philosophy or the principles of ethics. Then volume 2 will now only cover the regulatory aspect. In volume 3, all the guidelines, notifications, and other regulations will be in volume 3, and there will be a separate publication of case laws. So, case laws now is nowhere covered in these volume 1, 2, or 3. So, that is the first structural change that is made. Now, in volume 1, there are certain amendments which are, see, basically, I have before my eyes the audience, most of them are SME sector firms, that means small and medium sized firms. I am not having before my eyes, or I am not visualizing that this will be the participants from high firms, means very large firms or like big fours will be in the audience. And that is why my presentation is mainly focused and which is mainly meant for the people of average volume of practicing, and therefore we very few of us may have the listed companies audit, or very few of us may have very large size audits. It is not that all this code of ethics relates only to the audit practice. It covers all the gamut of practice, but still, when it comes to code of ethics, people always are under an impression that it is only applicable for audits, which is obviously wrong. Even in consultancy or advisory services, also ethics are all pervasive, friends. In fact, there is a case law, a High Court decision, where the issue was whether the ethics apply to the chartered accountants anywhere and everywhere they go, or only when they are acting as chartered accountants, or where the presence is only because of their chartered accountants. For example, if a chartered accountant misbehaves, now whether it is necessary to see that he does that misbehavior or misconduct only in his office, or in another CA's office, or in a client's office, or in a CA conference where his presence is there because of his being a CA, or even if he is on a pleasure trip, or even if he is attending a private function, even there ethics will apply or not. And the High Court said yes, ethics will apply anywhere and everywhere a chartered accountant goes. Now the logic is very simple and very straight, because see, the simple reason is that whenever such thing happens, the social media and the press will report as chartered accountant held for such and such thing, chartered accountant held for bribery, chartered accountant held for masterminding some scams. Therefore the whole image of the entire profession gets tarnished. And that is the reason. So that brings disrepute to the profession, and that rather the value of the profession also goes down. Therefore, one must remember that ethics are all pervasive. It's not a part-time practice, friends. Ethics is an attitude. Ethics is not a tactic. Ethics is not a style. Ethics is an attitude with which we have to behave everywhere and anywhere. So this is the first principle. And therefore, this volume 1, which talks of independence. Now, independence is the foundation stone of our profession. Although there are many challenges to the concept of independence, because so long as our client, the practical reality is that our clients pay our fees and our survival is based on that. And therefore, there are inherent limitations on our being independent. But still, whatever is possible, our council expects that they have made rules of this in the independence, and the independence is basically sought to be ensured by certain documentation. Like relatives, there are in the you cannot sign the financial statements of your relative, and the term of relative has also been quite enlarged. The scope is enlarged, and then also that what documentation you should have in your office to demonstrate that you are independent. See, you should not only be independent, but you should also appear to be independent. For example, a simple thing, friends, that if there is an audit team dedicated or assigned for a particular client, then even today it is required that you take a declaration from all the teammates or all the team members that they don't have conflict of interest with this particular audit. But in reality, what happens is in a small firm, and I'm repeating this, in a small and medium sized firm, most of our articles come from a very close source. Like, for example, they may be our client's son or client's close relative, or they could be something very closely related in some way, financially or otherwise, with the client. And therefore, we have our own constraints and limitations. But then you have to write a note. That is, I'm talking of even today. You have to write a note in your audit file as to, despite this, how you are independent. How is it that this particular fact that that person is related to the client has not affected your or had not created any conflict of interest, and how you have still acted independently without fear or favor? So this is a state of mind, and that state of mind has to be written on the paper in black and white. Only then you can show and demonstrate that you are independent. Now, in that, there are a few amendments where there are certain services which you can provide where sometimes there's a clash. Now, there is a separate topic for my talk as to which are the permissible and non-permissible services which the chartered accountant can render. Then there's an introduction of sustainability assurance standards, which I'll expand when I come to that. And then there are use of external experts. Now, while using the external experts, what are the threats to your independence or what are the threats to your ethics? That also is being discussed or is being amended. Now, the expanded definition, there is a concept called public interested entity or enterprise, where when the enterprise, when you are doing an audit, where the public are substantially interested, where the public interest is there, it's not a private individual or a private firm, but the entity where now there they have expanded the definition by adding that all publicly traded entities are included there, whether they are listed or not. Publicly traded entities replace, earlier the expression was listed entity, but now they have made it as publicly traded entities are deemed to be a public API. EPI means public interest entities. Then they have broadened the PIE categories, and now see, for example, there was a dilemma as to whether a charitable trust is a public interest entity. Now, earlier, public interest entity, because then in that the conflict of interest and whether you can do the certain services or you can render the services and the norms which are applicable to PIE, whether they can be made applicable to the audit of the charitable trust in general. And that dilemma was there. But in our code of ethics, in the public interest entity, the entity of charitable trust was not included. And whether even today, as far as I know, that under this new code of ethics also this has not been included. Otherwise, there was a dilemma, there was a question that arose whether we can still do the audit of these public charitable trusts. So, and then there could be some self, because independence means there could be some threats to your ethical behavior, like there are self-interest trait or advocacy trait. Now, next area of amendment is in the region of removal of 250 crores threshold. Now, NOCLAR, you may be aware that NOCLAR means non-compliance with laws and regulations. That means when in the course of audit, you come across anything where there is a breach or there is a violation of any law or regulation, then you have to act as a whistleblower. You have to take cognizance of it. You cannot ignore, because you cannot say that I am only doing the financial audit. And I am not interested, and I am not rather concerned whether they have committed any breach of, say, Pollution Control Act, or all these incident trademarks act. So all that, or even labor laws. Now in labor laws there is often a violation. So all that now we have to take cognizance of, and there was a procedure prescribed as to how to deal with these things which you have come across. So now you cannot be just saying that no, I am concerned only with the financial transaction. It's not that only financial transaction that you are auditing, but your scope has been enlarged. And in that, now all these while when the NOCLAR was introduced a few years ago, it was introduced only for the volume of company, that is 250 crore threshold was there. Now that 250 crore threshold, that is turnover, has now been removed, and it applies to all listed entities. See, there could be listed entities where the turnover may not be that high, but now it applies to all listed entities and all their material subsidiaries, and it includes concept of imminent breach. This is very important, friends. Because suppose you come across a situation where some law is likely to be violated. There has not been actual violation or contravention that you have noticed. But you see the overall situation is such that under these circumstances, certain law is expected or likely to be violated. That is called imminent threat or imminent breach. Now that imminent breach is also now covered in the obligation of reporting on NOCLAR. So now that means you have to be proactive, you have to be watchful, and you have to see whether the goings, or the rather the way the management is behaving, that there could be a likely breach of some law or some regulation. So that is now in volume 1, as I told you, the 250 crores limit has been done away with. So all listed companies are covered now, and imminent breach also, that concept also I have just now explained. Now further, this as far as imminent breach is concerned, there are examples that they have given. So in that examples that will be there when it is finally released, that we can come to know. Then key professional conduct changes which have been made is now, as I told you, there are two schedules to the act. Two schedules to the act means first schedule, which at present contains 4 parts, which is there in my PPT. Again, there's a separate slide when I deal with the actual code of ethics as of today. But I'm just highlighting one change that they have made. See, there are 4 parts in first schedule. First schedule is there are items of misconduct which are considered as of lesser gravity. Usually those items are such that which affect within our professional. That means which affects only our other member. For example, non-communication with a previous auditor, or advertising or solicitation of work, or doing business without the permission of the institute. All these things, an outsider is not concerned. You'll appreciate that outsider is not affected by that. Whether I am doing business with the permission of the institute or not, outsider is not concerned. Or whether I advertise or solicit or all those things, or I don't communicate with the previous auditor. Now, these are considered as first schedule offenses or first schedule items of misconduct. There are four parts of that. First part applies to the practicing CAs. Second part applies to the CAs who are in employment. Third part applies to both the categories of CAs. And the fourth part is other misconduct, which I will deal with later because there is no amendment there. In Schedule 2, there are three parts. One is practicing members, the other is to all the types of members, and the third is again other misconduct. Now, here they have made, in the part 2 of Schedule 2, they have made one amendment. And that amendment says that, see, today in part 1 of first schedule, there is a clause that when there is a change of auditor, then it mandates us to verify the procedure prescribed under the Companies Act has been followed or not. That means there should be either a general meeting or a special general, extraordinary general meeting, or and also there should be proper notices issued, a meeting held, attendance maintained, minutes are there. All these things one has to verify whether his appointment is regular. Now, in the amendment thing in the volume 2, that means the part 2 of second schedule, they have made one change. That means this major change is that you have to now verify whether your appointment itself is validly made or not. That means that is strictly in terms of the provisions of the Companies Act, section 139 to 141. That is whether you are eligible, whether your qualification, whether validity of the appointment. Till date, there was no such thing. It was general. That means the violation under the Companies Act was presumed to be an unethical thing or is a misconduct. Now they have made it very explicit. That means if under the Companies Act, whatever norms should have been followed for your appointment, as I mentioned to you earlier, which I told you was regarding the change of auditor. Now here at the basic entry level itself, whether you are properly appointed under the Companies Act, and even after appointment, you are to perform the duties strictly in accordance with the provisions of the Companies Act. So, the applicability of the Companies Act to your audit and right since your appointment and your performance of audit has been highlighted now by this amendment. So, this is very important amendment, qualitative amendment, and the objective is, of course, to uphold the audit integrity and statutory compliance. So that is, as I told you, is the amendment in the Schedule 2. Then they have permitted certain partnerships with valuers or other professional bodies, the members belonging to other professional bodies. So these are the changes as far as these volume 2, the management consultancy services. Because management consultancy services, as you are aware that as an auditor, you were not allowed to render or there were certain restrictions on rendering some other management consultancy services. So they have expanded or enlarged the scope of that. And now the new activities of management consultancy services which are permitted now, which will now include the forensic accounting. Well, by common sense, by general knowledge, we always believe that yes, it is an integral part of our audit profession. But now they have explicitly mentioned it, expressly mentioned it. Then research analysis services, then social impact assessment and evaluation, and artificial intelligence release and related services. That means AI related services, as our respected chairman also mentioned in his introductory remarks, that now our scope and the technology usage has been expanded, and it is now rather if we don't catch up with the technology changes, we will be soon outdated. So as he rightly mentioned that we need to have more and more focus on AI related services, and chartered accountants are now, they cannot now survive at all unless they are techno savvy. Our generation could do manage something without the much reliance on technology. Of course we cannot do away with the technology, but now it has become a very fundamental thing. If you know you are not aware of technology, or if you are not techno savvy, then you are illiterate. So now the new generation cannot afford to be not conversant with the AI or the artificial intelligence. Then the clause 4, part 1 of first schedule, that clause 4 is means, for example, the practice rather partnership with other than chartered accountants or other types of members like valuers. Now, as you are aware that regulation 53A, and they are already liberalized because there is a restriction on sharing of profits with a non-member. But they have already liberalized that many years ago, that yes, chartered accountants can have a partnership, multiple or multidisciplinary partnership with architects or with engineers or with cost accountant, company secretaries and lawyers. The condition was that those respective bodies should reciprocally permit their members to be the partners of chartered accountants. Now, a few of them have given their consent, but still, as far as I know, Bar Council and all has not given that consent. But otherwise, we can have partnership with engineers, with other professional firms. So that regulation, the scope they have now enlarged, and it introduces. There is one more thing: additional business or occupation activities. As I told you, clause 11 of part 1 of first schedule, it says that you cannot do any other business or occupation without the permission of the institute. Now, additional business, they have gone to the mode of intimation rather than permission. So they are now trying to do away with specific permission. See, in the regulation, there are two parts. One is the blanket or general permission to do certain things. For example, you can take a teaching job, you can be a trustee of a charitable trust. These are the things which are otherwise permitted, but may openly permitted. You don't have to, or like you are editing some professional journal. Now, these were the things which are already permitted. So even agriculture is included in that. But there the other part was there where you have to seek a specific permission. So now instead of that specific permission, they have gone to the intimation mode. Of course, there will be certain regulations and restrictions on that. But in short, it is a very great relaxation that we can say. Unless the details are released, it is not proper to, and please don't be too enthusiastic to immediately run for those things. But still, the basic principle will remain that when you are doing any other business, one has to follow the norms of ethics, and you cannot compromise on the ethics, principles of ethics. Then the certificate of practice fee, there was a restriction earlier that under the Act, how much maximum fee the council can charge for COP, which has been removed. So now council is free to charge any amount as the COP fees. So that there could be a threat of major increase in the fees also. Anyway, so now there's one more amendment at the disciplinary committee. This is a very serious amendment, friends, because many people say अभी इंस्टीट्यूट के हाथ में कुछ रहा नहीं, everything government is intervening, government is taking over. This amendment is one of the indicators of that. See, up till now, the disciplinary committee consisted of 3 members from the central council and 2 government nominees, and it was presided over by the president or the vice president of the institute. Till now, this was the position. In between, there was an amendment act which has not been implemented. But now they have made it clear that now the president of the disciplinary committee will be an independent person who will not be a chartered accountant. So, and he will be nominated by central government. That means now the government nominee will be the president. And this is a very, very fundamental change. One has to be very, means rather I would say it is alarming, because all said and done, there used to be earlier 3 members from our profession who are central council members and 2 government nominees. And up till now, and they have been very fair. I am not criticizing them. But ultimately, the attitude and the focus area always changes. When the government nominee is there, they are more concerned with whether there is a loss of revenue or whether there is a breach of or violation of any act. That they are more concerned. They are not concerned with your first schedule offenses, like which are internal matters. But Now the fact is that the disciplinary committee, let me clarify that disciplinary committee deals with the second schedule offences. Second schedule offences, I must repeat that second schedule offences are those which are also adversely affecting the outsider. This outsider will have a grievance. For example, your gross negligence or lack of due diligence, because of which frauds may take place, or your lack of due diligence because of this many irregularities have not been exposed. So your audit itself is defective, or your service itself is defective. Then the outsider is adversely affected. And that is why the second schedule offense is considered more serious, and the punishments are also high on that. I mean, there are more harsh punishments for the. And I am coming to the amendment in the punishment part of it. See, now today, for first schedule offense, which I told you was of lesser gravity, there are three types of punishments. Both these schedules, first schedule or second schedule, there are three types of punishment. There is a separate slide in my normal PPT of this code of ethics. But let me, because there is an amendment there, let me mention that three types for the first schedule are: first is reprimand. For example, it is a very technical nature. The misconduct is of very technical nature. Then it is a reprimand. That means it's a warning. Then, second type of punishment is the fine up to rupees 1 lakh. And the third is suspension of membership for the period not exceeding 3 months. These are the, just to recapitulate, first is reprimand, second is fine up to rupees 1 lakh, and the third is suspension of membership for not more than 3 months. That is the first schedule. But in the second schedule, the punishments were: the first is reprimand again, but the second was 5 lakhs, fine up to 5 lakhs, which is now increased the maximum fine. Earlier, now they have increased it to 10 lakhs, and there is a power given to the council that they can directly punish the firm or a member if there are repetitive misconduct found in one same firm. For example, one partner of a firm is found guilty under misconduct. Then within a span of 5 years, another partner is also found guilty. Then the council, see, as of today, council has jurisdiction only on individual member, not on the firm as of today. But this power now can enable the council to directly punish the firm. So this is a very major and fundamental amendment, that without carrying out any proceeding, merely because two partners of your firm have been found guilty within a span of 5 years, then the punishment can be directly inflicted on the firm. Then there are, as of today, the inquiry, there was not much mandatory time limit as to the completion of inquiry, but now it has been brought and the committee is required to conclude its inquiry within 180 days, that is a span of 6 months of receiving the preliminary examination report. Now, preliminary examination report means perhaps what they are referring to as prima facie opinion. There is one stage in the disciplinary conduct of the disciplinary mechanism, that there is a prima facie opinion, and after that it goes to the committee. Till that time, it is within the jurisdiction of the director discipline, who are bureaucrats. So once they hold you prima facie guilty, then there is a hearing. And as of today, the experience is that the hearing continues for a long time. Long time means may take even 3 to 5 years. So you cannot keep all these things because that's a sword hanging on the head of the chartered accountant also. And then it becomes too late. So then giving the evidence and so many things are arising out of that. So now they have put a limit. Then there is one more section which says that if a non-member, or these are, see, like in medical profession also there are quacks. So in our profession also there are quacks. I know a few official areas where a person who is not a chartered accountant also projects himself as a chartered accountant. He displays on his office also the board as a chartered accountant. But earlier there was a fine of only 1,000 rupees. So some people told me that this person, there are many times he was fined, but by just paying 1,000 rupees, he is again free to commit same type of thing. So this is a very dangerous thing. So now that fine they have made to 1 lakh, and the fine for subsequent offences is made to 5 lakhs. So it's a little prohibiting figure, because 1,000 was too paltry a sum, but now it is 1 lakh for the first time, and if it is a repeated thing, subsequent offence, then it is 5 lakhs. So there could be some deterrent effect, which is a welcome thing, which is of course affecting the outsider, not our members. Then companies not to engage in accountancy, yes, companies as such, because we only individual member can be a chartered accountant. There can be under corporate form, there are restrictions as to what services you can render. Then, as I told you, the fine was for the second schedule offence is now proposed to be increased from 5 lakhs to 10 lakhs, and for the fine up to the firm, which could be now as high as 50 lakhs rupees. So you can imagine that if there are means new provisions allow the disciplinary action against a firm if a partner is a repeat offender. This is very important. Habitual offender, then this includes a fine of rupees 50 lakhs or prohibition from practice up to 2 years. So that is of the firm. It is not suspension of membership of particular individual partner, but the seriousness of this, I hope you will appreciate the harshness of this, that will act as a deterrent. And all partners of a firm will try to mend their ways of conducting the profession, because the fine of 50 lakhs rupees is no doubt a very high figure. Now, of course, that's the maximum that they can levy. It's not that for every case they will go for 50 lakhs. Now, most of the concern of most of our members is, and their grievance is that we are not allowed to advertise. Now, friends, let me tell you one basic principle, that we shout of this advertisement, we should be permitted. We need to introspect, friends. It's my personal view, and that is in line with the council's view, which was there so far. How many clients really come to us by looking at our visiting card or by looking at our board on our office, name board? See, this is essentially a fiduciary service. And we go to a finance professional only through a proper reference or some known person recommends us. It is very rare that by looking at the advertisement, the common man or any person or the corporate are rather known to be more knowledgeable about this. So no, they cannot be influenced by your advertisement. Still, people wanted that liberty to advertisement. So in the write-up, now the commentary is the amendment is that the guidelines of the year 2008 advertisement guidelines, there are now in the contemporary forms also, like in social media also, you can have the advertisement, but advertisement means very restricted sense. You cannot advertise your professional achievements or your professional services. You have to simply indicate that you are a chartered accountant, but you cannot even mention who are the clients that you are handling the service or rendering the service. So website guidelines are also now amended, and those detailed guidelines also will be available only when, but that is also on domestic networks, which is the present times is the making the same applicable to recognize domestic networks also. But there also you cannot mention the firm name. Then you cannot mention the types of services that you render. You cannot also mention your professional achievements. For example, if your name, see, there are sometimes online third party website. So some other websites are there, like the newspapers or many other banks. They have their own website for rendering consultancy services. On that, they retain the services of chartered accountants. That means the queries come to them on their website, and the chartered accountants retained by them answer those queries. There, they may mention that the person who is answering the query is a chartered accountant, but he cannot they cannot mention that the name of the firm. The name of the firm should not be projected. And then consultation and advice through the websites which are given. Then besides consultancy and advice, no other service can be rendered. So it's purely the advisory nature. Now you cannot solicit the work by advertising that you will render these other types of services also, because it is purely advisory services, and the professional achievements, as I am repeating, that the professional achievements and the firm's name cannot be protected. Then there are certain amendments in the advertisement guidelines, which will appear in the website that you can go through, but that is not yet released or published as yet. But those guidelines, by push or pull mode, anytime is now permitted. But now, if, for example, if you are giving an advertisement for the staff recruitment, so there also you cannot mention that a well-known firm or some such thing. You have to simply say such and such firm chartered accountant that we need staff or we need articles. So any promotional element or anything that is suggestive of an advertisement should be avoided in that. So it should be a plain advertisement giving information only, and it should not project your image of the firm as if it is a senior firm. You cannot say that a 50-year-old firm or a very well-known or a renowned firm. Such type of adjectives are not permissible. So then, as I told you, the structural changes means in the volume 2, volume 3, they have amended. That I think completes the major amendments which are proposed. And now with this, I come to the normal code of ethics. But again, I appreciate the committee of our WIRC council that yes, it took about 45 minutes to deal even with the amended or rather proposed amendments even before they have been implemented, or the due date of implementation is the 1st of April. The things have not been released, but still there is a significant change that you can appreciate, that there will be substantial amendments, but when the details are published, only then it will be proper to comment on them or to elaborate on them. So with this, I go to the now proper our existing code of ethics. Whatever queries you may have, you may just send it on mail or something, because unless the official release is there, it is not proper on my part also to clarify anything. Now, this is a very important note, which again I am mentioning, that the revised code of ethics effective from 1st of April 26 has not been published by the ICI so far, and hence no PPT could be prepared. Now, we heard our motto song, Yo Yesha Sukteshu Jagarti, which is adopted from Kathopanishad, and which means that he who is awake when the world around is asleep. Now, the introductory part, the ethics, of course, you are aware, is a moral standard, moral values, and the code of ethics earlier, which was code of conduct, which I have explained to you the implications of the change of expression, code of ethics, and the eternal vigilance is the cost of independence. Now, we have discussed the term independence. Now, who can be independent? See, for example, our soldiers who are there on the border, eternally vigilant to guard our borders. Now, only then, because of them, we are independent. We can say and we can enjoy our routine life. But if you are not vigilant, then you cannot be independent. So your independence will be lost. And that is why it is eternal vigilance. अखंड सावधानता ये आपके स्वतंत्रता की कीमत है. That's the cost. So that one has to recognize, because I see many chartered accountants are conducting their practice very loosely, in a pathetic manner, and sometimes it is very difficult to defend them when there are complaints against them. So in the field of ethics, as I mentioned, you are either ethical or unethical. There is no in-between stage. What is the need for code of ethics? People say that this is a burden on us, which is not, friends. It is not a burden, but it is a shield to protect us. See, there could be an error in your professional judgment. But if you can prove that you have followed the procedure, if you have followed the rules of ethics as per the protocol prescribed by the institute, then your there is some benefit of doubt that can be given. See, we are human beings. There could be a professional error in the professional judgment. But yes, I have applied this thing. For example, I referred while giving advice, I referred to certain case laws of good standing. But finally, I referred to some High Court decisions. Finally, the Supreme in my working papers, I have noted that I have relied on this. Now, whatever you have relied, if finally is your vigilance or your diligence should be recorded and it should be apparent in your working papers. And the society's expectation is that because society has a lot of grievance against our institute in the sense that they say that your punishments are very mild and you take a very long time in disposing of the complaint. So that means the society expects, public at large expects that the so the society or the public expects that the code of ethics should be enforced very strictly. And therefore, you cannot keep on crying that oh, this is a burden on us. And many people say that the other professionals do behave whatever way they like and there is no one to control. Friends, you should always remember that the grass is always greener on the other side of the pasture. So therefore, it's not that other professions are also enjoying or merrymaking. They have their own grievances. So the first thing is that the code of ethics it is very necessary. That is a shield to protect us. So we should have a positive frame of mind. And our Saurabhji also rightly mentioned that we should have a positive frame of mind in everything. Whatever work we are doing and whatever things we are now planning to do, there has to be a positive frame of mind. Our sources, as I tell you that there was a mention in my introduction about the mythology. But in Taittiriya Upanishad, there are three messages. There are many messages given to the students. But there are three messages which are very prominent. One is Satyam Vada. Satyam Vada means speak the truth. Then Dharmam Chara. Dharmam Chara means follow the rules of ethics very religiously. And third one is Swadhyayat Ma Pramadha. That means keep on upgrading and updating your knowledge. That is our CPE, friends. So CPE was contemplated in our country thousands of years ago. That means, see, earlier the training was of 12 years in the Guru's ashrama, they used to stay, the students. And after 12 years, they used to come back to the society. But that does not mean that the education was the end of the education. The Gurus used to advise them that they should keep on updating and upgrading their knowledge. So that is our CP. But the present image, friends, is that we are losing our credibility. Why we are losing our credibility? Because the government also, they also feel that so many scams and so many frauds have taken place in our country, thousands of them, especially after independence, and there is not a single instance where the fraud has been exposed by the auditor. So there are inherent limitations of the audit. Our institute or the council also recognizes the fact that audit is not necessarily the fault finding or fraud finding, which is not a detection of fraud. But friends, earlier the concept was auditor is only a watchdog and not a bloodhound. Now this principle is getting diluted. Why it is diluted? Firstly, as I mentioned to you, the government's perception is that not a single fraud has been detected by the auditor. This is one. And that is why they feel that we are simply accommodating the client. Well, there are financial reasons, there are very practical reasons. I appreciate all that. But at the same time, there is a crisis of courage everywhere. So we are not bold enough. And why we are not courageous? Because there is no unity among us. See, if we are united, only then we can have a collective strength. Till that time, we cannot have a collective strength. So if you want to be ethical, there is no sense in only one. I'm following my ethics. The other persons are not following. But you cannot have a grudge because ethics is your own satisfaction for that you are working. So they avoid, and in fact, there were in the checklist of an institution, they have expressly mentioned, please avoid bringing chartered accountant certificates as the same are often found unreliable. So that means we are not assertive, we are very accommodative. That is our present image in the society. In fact, people say that chartered accountants are the people who manage everything. And we manage everything to the extent that even CP hours also people manage. And that's the tragic part of it. We don't understand the seriousness, we don't understand the spirit behind it, and we always try to find loopholes in any law and regulation. When any law and regulation is passed, the first reaction of a chartered accountant is, अगर ये नहीं करेगा तो क्या होगा? But as again that, if we try to understand the spirit behind it, and we also try to educate our client that yes, by following these rules of ethics or by following the law, everybody is going to be benefited. Only then our country can progress and our profession also can progress. Otherwise, today the public at large, they say that whenever there is a fraud occurs, they say auditor क्या कर रहा था? Now, if that is our image, then I think we need to introspect very seriously because we do many things in too much of good faith. See, two things we have to always remember, and that is the fundamental of our ethics. One is work should not only be done, but it should be seen that it is done. That means everything has to be documented. You document only what you do, and whatever you do should be documented, and whatever you document, only that you have to do. The ISO also, that the certification also is having the same principle that without documentation you cannot do the practice. And that is not relevant only for the practice as a CA, or it is not relevant only for the profession, but even in our personal life, the documentation is of utmost importance. And as of today, without any document, you cannot do anything. So even in your personal life, that is equally important. Second is the faintest of ink is stronger than the strongest of memories. See, you may have very large, means your memory is extraordinary. You can say that I have called him 100 times, I have called him, I have sent message 10 times. But unless you write it, there is no impact. See, our this basic theme as auto is impact. Now, impact can be achieved, especially among our clients and other people, only by a written communication. And now there are many gadgets, technology, which makes our communication very easy. See, earlier our chartered accountants, for prior generation chartered, they used to feel shy. That if they are advising something to the client, then they used to feel shy as to how to take acknowledgement of it. And so they used to give only oral advice. Now you can always write an email to him. So that is the ink is stronger than your strongest of memory. That principle one has to always inculcate. And then we are not proactive. As a chartered accountant, we start our audit only at the 11th hour, we run around. So if and our clients also are used to that. So even if 30th September is the last date, and if the the client comes to you on 27th or 28th, still we try to accommodate. And then when you are doing anything urgent, now I can give you the examples of good faith. See, today we are in Kali Yuga, where no relations are permanent. I tell you because actually I have handled really hundreds of disciplinary cases of misconduct, and if I can share a few of the real life stories, they are not imaginary cases. See, husband and wife both were chartered accountants. Wife did the audit of a cooperative society, housing society, for 3 years. After 3 years, the husband did it because they were practicing as separate chartered account, proprietary concern. In the 8th year, there was a divorce petition between the two, and the wife filed a complaint against her husband, ex-husband, saying that he took the audit without my NOC. So to this extent, now the today's generation has gone. They don't believe anything, no relations, nothing, no sentiments, no emotions. They are totally, well, the less said, the better. But there are no relations which are permanent. That is why I have come across disciplinary cases, the complaints made by father against son, son against the father, brother against brother, brother against sister, friend against friend, partner against partner, articles against partner. You consider all permutations and combinations of relationship, and those types of complaints and the disciplinary cases have been handled by me. So, because another thing, we have an obsession of tax considerations. That is why we quite often tend to ignore or underestimate the importance of audit principles or legal principles. Now, this lack of proactiveness, as I told you, that we wake up very late. And when we wake up, it is too late to raise a query. Because the client then says that, अरे ये तो 15 महीने के पहले जो किया था, that you are asking just now. Although he is himself responsible for that because he comes to us at a very late stage. But now, for example, because see, it's a very pitiable situation. The way chartered accountants have to slog day and night when there's a tax season, the tax filing season, and that is the pressure created by themselves because they don't have the courage to write to the client that unless you bring your records within a particular time, we won't be able to do justice to your work. That kind of courage we are lacking because we don't have unity. If you refuse to do certain work, or there are other chartered accountants who can easily take it up, and they are not bothered about the scruples, they are not bothered about the ethics. But if all of us are ethical, then only the profession can thrive, the profession can prosper. So the obsession with tax considerations, that means we always feel that, array, whether this is allowable under tax, then we give go by to the accounting standards, we give a go by to the company law provisions, other legal provisions. Now I can give you hundreds of such examples where of the documentation also. See, there are cases where what is important and what is expected of us is professional skepticism. Now, professional skepticism means it doesn't mean that you suspect everything. You can trust, but you have to verify. But we blindly trust. And then, now I'll give you a good example. There, in fact, dozens of examples I can give. But see, client tells us something and we accept at the face value. We don't verify. So what happened was there was a very big company with very high turnover and they had some mines somewhere in Orissa and the corporate office was in Mumbai and there was a loan of 100 crores from an PSU bank and it became a SIC unit, means an NPA. Now remember, whenever there is an NPA, all the big banks, nationalized banks, they have a standard practice of catching hold of the auditor because ours is a soft target. Our profession is a soft target. So we are always made a scapegoat. And unless we are united, we cannot, because see the type of certificates the banks and other institutions expect us to issue, they are ridiculous. Like certain banks ask us to issue that the entity has complied with all laws. All laws, even that entity is not aware what laws are applicable to them. And they also ask us to give a certificate that they will further also in future comply. Now that's the most absurd and deplorable way of asking certificates from chartered accountants. But we are not united enough, so we cannot resist all this in a collective manner. And therefore, then our people, especially in Mufussil area, fall prey to such things because the tempting fees are offered. I'll give you an example. See, say some large listed company somewhere registered in Ahmedabad, 10,000 crore turnover, and on their list of their team, rather, that very big reputed statutory auditors, company secretaries, cost accountants, management consultants, finance consultants, legal advisors, all these are big team, very impressive names are there. Now their stocks are, for example, 6 to 800 crore rupees. They catch hold of some small time chartered accountant somewhere, maybe even in Mumbai, and they will ask him to issue a stock valuation certificate within a span of 3 to 4 days. And they will offer him a fee of say 1 lakh rupees. Now that new entrant in the profession gets excited. अरे 4 days का काम 3 days का काम करके if I am getting 1 lakh rupees, which is very much lucrative for a new entrant in the profession. And look, what happens is he always thinks such a big organization is there, some big people are there on the at the helm of affairs, so everything should be proper. Why go into the depth of verifying anything? But the professional skepticism means that the first question should arise in his mind as to why they are coming to me. I am such a small chartered accountant. If such a big company is there, listed company is there, why are they approaching me? This is the first question that should arise in one's mind. See, for example, I happen to be a director in a small cooperative bank. Now, if a large corporate who actually wants 2000 crore rupees approaches us for, say, because we, for example, our limit is 200 crores at the most. Why is he approaching us for a loan? He should have gone to a big bank. But that person may be under an impression that it is better to pressurize a small bank like a cooperative bank. So likewise, these large corporates, because the large firms charge fabulous fee for this and they rather avoid such certification. And that is why it comes to small people. So if that is there and these small people unfortunately do not retain any working paper whatsoever, they don't even get the appointment letter, they don't even know where is the stock or godowns or warehouses are located, what is the kind of stock, nothing. And how many people they employed for verification, what are the queries raised, what is the how is the valuation made, FIFO method, LIFO method, average, what are, there is nothing, not a chit of paper with them. They simply sign it. And because of that, there was many such cases because the reality stock, as against 600 crores, the real stock was 30 to 35 crores. Now there are big scandals like this. Today, friends, unfortunately, can share with you a very tragic reality that today hundreds of chartered accountants are on bail and dozens of them are in jail. And the basic reason is that whenever there is a fraud, and quite often it is a management sponsored fraud, and in such frauds, now it has become very customary for the regulators or for the investigating authorities to make the chartered accountant or the auditor as a co-accused. And if he is a co-accused, the poor fellow has no even resources to defend himself before the investigating authorities, before EOW, before SIFO, or even in the courts, criminal proceeding, magistrate. He doesn't have even that kind of resources. And the poor fellow is really suffering like anything. But the criminal proceedings take years together to resolve. Until that time, this person is hanging in bail. Now, this is a very pathetic situation of our chartered accountant friends. And unfortunate part is that the other chartered accountant community is least bothered about our fellow chartered accountants suffering. See, our institute, when it comes to the disciplinary cases, they recognize this principle that audit is not investigation. Audit, the focus is different. Audit has its limitation. Investigation is a different thing. All that they recognize. Audit is not necessarily the detection of fraud. All this is recognized, accepted. But when it comes to the volume of the frauds, then they are also helpless and they say that no, yes, if this person should have seen this, then this would have been detected, and so therefore is professional negligence. The fundamental thing where we are lacking, the chartered accounts are lacking, there are 3, 4 areas where we are lacking very miserably. First is, we chartered accountants do not verify the company secretarial record. When I say company secretarial, I also refer to as for a cooperative society or for trust management, the minutes, the attendance record, all that we are not much bothered about. One more area where there are fixed deposits, receipts of the charitable trusts, and chartered accountants do not care to verify the physical existence of those fixed deposit receipts. And in reality, most of the fixed deposit receipts have been fraudulently encashed. There are 8 to 10 cases where large charitable trusts, the trusted employees, or sometimes even the managing committee members, have fraudulently encashed such fixed deposits in the bank. Now, professional skepticism means, for example, there was a charitable trust where there were two young boys who were doing the accounting and also the some accounting administration. They were from very poor family, and the internal auditor and statutory auditor were very reputed and very conscientious auditors, and they had helped these boys when they were very young to accounting and other things. Now they are there for 20 years now. They are doing the accounting. First 10 years they performed very excellently, but in last 10 years they committed a fraud to the tune of 5 to 6 crore rupees because good faith. Both internal and statutory auditors had a blind faith in their integrity. And every time what used to happen that they used to encash such fixed deposits and they used to transfer all those amounts exactly to their own accounts or to their own firms, and they used to mask the entries in the bank statements. And those entries, because then the final balance used to tally. But they never questioned as to why these are Xerox copies of the bank statements. Why original bank statements are not produced? If simple question had been asked, the fraud would have been exposed. So, professional skepticism means suddenly in a particular company, the turnover is shooting up like anything, profits are shooting up. Then you have to smell something that there could be circular transactions because of which the turnover is inflated. So they might be going in for an IPO or anything. So, and chartered accountants do understand this. Question is, we don't take it to the logical end. And therefore, your queries, or first thing the institute asks, the council asks, disciplinary committee asks, is where are your working papers? Even appointment letters we are quite loose about. And once you get the appointment letter, it is also this the SA 210 says that you have to give an engagement letter. See, this short span of time, I cannot cover many areas, but I'm just mentioning them as and when it occurs to my mind. That engagement letter, giving the engagement letter is also mandatory under SA 210. But that hardly any chartered accountant gives. So the other area which I mentioned to you is in case of working papers, firstly, we are very loose about the company secretarial record. See, there was another very important point which I have come across, and I'm sharing my experience. There are two such points. One is usually in a group, only one director or one partner or one trustee interacts with the chartered accountants because the others are either not interested or they are not much conversant with the accounting, with the paperwork and all. Now, sometime or the other, there are bound to be disputes among trustees, among managing committee members, among directors, among partners of the client. There are bound to be disputes, and even the family members, even brothers. So, when there are such disputes, what they do is they just blame the chartered accountant and their own guy who is always interacting with the CA, saying that this director of ours who was interacting with the chartered accountant had something hand in gloves with the chartered accountant and they have committed all these whatever fraudulent things they have done. And they disown the balance sheet also. Because what we do is we have to obtain, that is why I say the basic thing what one needs to improvise in the day-to-day working is at least one hard copy of the financial statements. We obtain signatures of all directors, not merely two or three directors, all managing committee members, all trustees, all partners of a firm, because otherwise later on they disown it. One more thing I have come across in the course of my this practice of misconduct cases is we don't take from the client the details of their bank accounts. And I'll give you a very interesting example. See, there was earlier these nationalized banks had a practice of giving unsecured loans to the extent of 50 crore rupees to the companies. Now, in one particular case, there was a loan of 40 crore rupees given by the nationalized bank to a listed company. Then, after 2-3 years of time, they found, or rather, bank thought that it is not proper to have the unsecured loan to this extent. So they went in for the registration of charge against that thing. So they wanted to make it secured loan. When they verified that, it was revealed that in the financial statement, this loan of 40 crore rupees did not appear at all. That means it was not forming part of the accounts at all. And there were 3 years, there were three reputed forms of internal audit and 3 reputed forms of statutory audit, and none of them noticed it. Obviously, because there was a secret bank account. And when the CBI report came to me, I found that this was not the only loan that they had given. The 40 crores was an enhancement. The previous year, there was a 25 crore loan, and even before that, there was a 20 crore loan. That means all told, it was 85 crore loan, and that is why the bank thought it should be secured. Now, had we obtained the list of bank accounts, that is why the management representation letter is not only one-time affair of while signing the audit. Even at the time of appointment, I think you should take certain information as to what is the authority structure, where are the bank accounts, what is the type of business, who are the major customers. All this, if you take on record, that is your audit permanent file, and every year you have to keep on updating about the bank account. Because what is done in reality is that whenever new bank account is opened, the bankers say that there should be some resolution and all, and everybody, because everything there is always firefighting, so they just create the resolution on the computer and they give that resolution copy to the bank, and it is not recorded in the minutes at all. In fact, there are many cases where the last turnover case I am telling you is that in the dispute among the two brothers who were directors of a company, one of the time complaint was that the car of the company was registered only in the name of one director and the other director was a complainant. So he said that there should be a remark in the audit report that the car is not registered in the name of the company. Now one has to introspect, friends, that how many of us really verify the registration of vehicles, whether it is in the name of the company or not. And if it is not in the company, then there has to be a documentation like resolutions and all. And it should be there should be a note either in the notes on two accounts or where somewhere there should be an in disclosure that this car stands, although the company is treating it as its own asset, even claiming depreciation also on it, that does not make it its company's asset. Because depreciation under Income Tax Act is basically based on the beneficial ownership, beneficial user. Whereas here, the legal ownership is also equally important when you are auditing it. But these small things are missed out. Similarly, whenever there are big private limited company particularly, people say that two directors have signed, therefore they sign. That is also a wrong conception, friends. Because it is not enough that only two directors or three directors sign and then you sign. What is the of utmost and fundamental importance is that it should be approved in the board meeting. The financial statement should be approved in the board meeting. And then the second subsection says that it should be authorized. The board authorizes two or three of them to sign the financial statement. And subsequently, the signature is a consequential thing. Therefore, what is of fundamental importance is the approval in the board meeting. But we do everything for the client, all documentation we only do for small companies. But for our own safety, there is one simple thing that we need to take, that these financial statements were approved in the board meeting held on such and such date. This simple letter we are not taking from them, and then we come into trouble, because then the other directors, they simply say and disown the thing. They say that this balance sheet was never produced before us, Meetings were never held. Board meeting was also not held. Even the AGM was not held. Balance sheet was not shared with anyone. So this secretarial aspect, one has to take utmost care to ensure that all these formalities have been complied with. Because there are very, very common complaints that many people say that these were not circulated among members. Even the directors say that they were not aware of it. So these are the small things which we need to be very careful. Now in that Orissa mines, there's one more very interesting thing that had happened. See, there the firm had maintained excellent working papers, very impressive manner, and we had submitted that. After 2 years, there was a small query from the council, the disciplinary committee, asking only two questions. One is whether the bank statements you had written to the banker to confirm the bank statement, the veracity of the bank statements. The chartered accountant firm told me that we had not written to the bank, but we have the photocopies of all the bank statements and the accounts are reconciled. Then I said, very good. But then they told me that a few of the bank statements were fabricated, which we never even imagined that this could happen. But people go even to that extent that even the bank statements they fabricate. And you see some cooperative bank in Bhubaneswar or Orissa or Guwahati, we don't go to verify, but then it is your duty to write to the banker and to get the confirmation of the bank statements. This is another very, very fundamental thing that we need to do. Secondly, the second question of the institute was whether you had written to the debtors and creditors for confirmation of balances. Unfortunately, we chartered accountancy, while doing the audit in Karo, Mao, Karo, all types of audit reports, we simply say that all balances of debtors, creditors, lenders, etc. are subject to confirmation. Now, this is not enough, friends. This is a very loose type of statement. This is an omnibus statement. You have to first show that you have made at least an attempt to obtain the confirmation letter, because many people say those nobody writes to you, nobody responds. Well, that is a different story, but it is your duty to insist upon the client that they should write to the respective parties, that is major parties, selected parties, and also write there that the reply should be sent directly to the auditor. This is a very basic thing, but third party evidence, I am repeating that today the focus and the emphasis is on third party evidence, which we are very, very much lacking in verifying. As I told you, bank fixed deposit receipts, we don't verify. We don't go to the bank for confirming the bank statements. We don't write to the debtors, creditors, and lenders. And because of that, many frauds are taking place. I can give you some very interesting examples. Because the paucity of time, it is not possible. But so there was one complaint made by the director for a very funny reason. Because now, as I told you, there are no permanent relationships. So the people have understood their nuisance value. So any Tom, Dick, and Harry can easily make a complaint against you. And here the cause of the complaint was that they had a very long and cordial relationship with the firm, the directors of the company and the firm. But the director had approached the firm with a request to accommodate his daughter as a dummy article, which the firm had refused. And because of that, as a vengeance, he filed a complaint. And on these technical reasons. So, friends, this means nuisance value they have, and such frivolous complaints are coming up. But unfortunately, our institute is also helpless. There are certain principles which have evolved over the years. So, there are four authorities under the Act. First, the disciplinary directorate, who are bureaucrats. Then there is a board of discipline, which consists of three members, which is one is government nominee, which deals with the first schedule offences. Then disciplinary committee, which consists of 5 members, where there are 2 government nominees and 3 central council members, which, as I told you, the combination is going to be changed. And the last is appellate authority. Now, because of the time constraint, I am not elaborating on it, but the first stage, the complaint goes to the director discipline. He processes it, and then only actually the proceeding, the hearing, etc. starts. And there the restriction of 180 days has been introduced in the new code of ethics. So the disciplinary committee, there are 4 benches of the disciplinary committee, and the pendency is huge. So even today, the cases filed about 10 years ago are still going on. Now, people quite often ask whether there is a time barring on this. There is a loose type of time barring. Time barring says that the complaint should normally be filed within 7 years from the date of the occurrence of the event which is complained against. For example, date of signing of the balance sheet is the occurrence of the event. Within 7 years, the complaint is filed. But remember, friends, it is not a blanket time barring. There is a restriction, there is a rider to that. It says that if the disciplinary director or the disciplinary committee is convinced that production of evidence is now difficult or impossible, or it is otherwise impossible to conclude the case, then only they will refuse to entertain the complaint. Otherwise, because it's a quasi-criminal thing, and there is no time bar for that. Now, I'll give a very interesting and classic example of this. See, there was a will prepared by a lady. She died after 12 years after preparing the will. When the will was opened, a chartered accountant had signed it as a witness, but that lady had not signed it at all. Now, this obviously means that there is no other evidence required. The chartered accountant was obviously guilty of misconduct because he has signed as a witness. What does it indicate? It indicates that the person has signed before him in his presence. Now, that's a false statement if he is signing it. Because we are signing as a witness, you cannot take it casually. So, in good faith, he might have done it. The concerned party would have said that we will obtain that lady's signature a little later. She is today in the hospital or something, and he must have trusted them. Friends, I am repeatedly urging on you, I am repeatedly requesting you, please don't do anything in good faith. If you do anything in good faith, you are bound to invite trouble for yourself. So, there are many such instances. There was also these NAFRA matters that just now I'm deliberately avoiding dealing with that, but there this issue of SA 210 engagement letter, that NAFRA's one of the allegations was this. Then there was a lady who came to the CA's office. She had some friction with the chartered accountant, and from mischievously from his mobile, because otherwise she was quite familiar. Her coming to the office was very frequent. From the chartered accountant's mobile, she sent very dirty and obscene messages to herself and took a photograph of the screen of the mobile, and she approached the police and she approached the institute saying that this chartered accountant is bringing disrepute to the profession. So there are thousands of such examples. But now let me come to the disciplinary mechanism where basically if you make a complaint, then and if the complaint is against the firm, then the disciplinary directorate, they write to the firm as to who is the person answerable on this. That means so the signing partner, then there could be some director, manager, because there is a hierarchy, and in large firm there is a system that they can identify as to which part of the work was done by whom. In a small firm, there is no such system, but in large firm there are such systems where they can identify that this particular aspect was verified by such and such chartered accountant who is working in the firm. A junior partner may be there, manager, director, senior article, whatever. Senior article cannot be made liable because he is not a member. Now, so this is the first step. Secondly, there could be a complaint or information. Now, complaint or information means, now this is a slide. Complaint or information means, complaint means there has to be in a prescribed form, and there is a fee of 2,500 rupees which the complainant has to pay. But information is just an information which is passed on mostly now by regulators like ROC or the Register of Cooperative Societies, or National Stock Exchange, or SEBI, RBI. These are regulator bodies. If they find that there is not much serious loss to the revenue, But there are procedural lapses in the financial statements, or there are lapses in the financial statements, though there is no loss to the revenue, no loss to the public, no loss to the bank or anything. Still, they what in such case what they do is they just pass on that information to the institute. Then the director discipline writes to them that whether you want to only stop here as an information or you also you have to file a complaint. If they don't file a complaint and it is just an information, then there are two consequences. One is that the informant, that means the person from whom the information is received, is out of the picture now. The institute writes to them that then we will proceed against our member and we will only let you know the end result. But you are not a part of the proceedings. Unlike that, the complainant is there in the picture throughout the proceedings. That means whatever complaint is made by him, it comes to you, to the respondent. The respondent has to give a reply, and that reply is called written statement, which is given to again back to the complainant. The complainant writes a rejoinder to that, and then our director discipline verifies whether there is a prima facie case, whether the prima facie person is guilty or not. That he decides. Now, next principle is, as I told you, that the procedurally board of discipline deals with this PPT will be shared, so you can later on see. I need not pass time on that. Constitution of the DC also I have mentioned. Then important principles. So first is complaint or information. Second is there is no requirement of locus standi for the complainant. That means a complainant may be totally stranger. He is not related to that particular company, not a shareholder, not a director, not an employee, nor a lender, nor a borrower, nor a debtor, shareholder, customer, creditor, nothing, no vendor. He has no relationship whatsoever. Still he can complain because as I told you, these are quasi-criminal things. So any outsider also can complain. And there are professional blackmailers, friends. So they just pick up a financial statement, and if there are any flaws, then they can still file a complaint. So this is a very dangerous situation in our profession. And there are many such complaints that have taken place. Third is the complainant need not come with the complaint with clean hands. See, normally the legal principle is that the person who is seeking justice has to come before the forum with clean hands. But here, there is no such requirement. Now, for example, the complainant may be himself a criminal. The complainant is himself a convict person behind bars. Still, because remember, and it is rightly so, our council says that see, we are not concerned with the character of the complainant. We are not concerned with the conduct of the complainant. We are concerned with the conduct of only our member, because our motive, which is rightly so, is that our member should do or perform his duties properly. If he is not doing it, he is not fit to continue as a member. So they see what you have done and not the complainant has done. This is very important, friends. They don't decide the civil or rights or liabilities. They only say whether you have acted professionally in a correct manner. So this is very, very important principle. So they need not come with clean hands, and the council is not concerned with the locus standi of the complainant, as I mentioned to you. Then this was a proposed amendment then that they director discipline was given a power to refuse or reject the complaint at the threshold if it is a frivolous one. But there is also one more thing, that earlier and even today, the complaint, there is a possibility to withdraw the complaint. Earlier it was not allowed. Again, the 2006 amendment, it was allowed that a complainant may withdraw the complaint. But if it is a very serious nature, because this he can do only with the permission of the disciplinary committee. So if the disciplinary committee feels that the allegations are so serious or so grave that it is not proper to just leave or exonerate the respondent, because then he will continue to do bad things in future. So therefore, with their permission only. So for example, if it is of technical nature, or if it is of a personal thing which has been compensated or which has been taken care of, or there is a court settlement there, and in the part of settlement they say that we will withdraw all the complaints, that can be withdrawn, but not if their charges are very serious. So, and the next principle was that, as I already mentioned, that council has jurisdiction only on members but not on the firm. That is why when the complaint is against the firm, they ask as to who is the member answerable. But then at the same time, I have clarified that they can directly now punish the firm if there are repeated offenders in the same firm. So they can directly punish, but they don't go or they don't undertake any proceedings against them. So this is very important that directly they can punish. Then even if the respondent compensates the complainant, for example, because of your wrong advice, the complainant was required to pay some tax, interest, penalty, and many other things. Then even if you compensate him, even then you cannot undo what has already been done. So your misconduct has already crystallized. So your wrong advice, for example, you missed out on section 56, 50C of the Income Tax Act or 56. I'm talking of before the amendment. Now sections might have changed. But if you are missed out on that while giving advice, then you have to still continue to be liable under the misconduct, even if you have compensated him. Or another principle, and this is very, very important principle, friends, that whether because of your lapse or whether because of your misconduct, whether anybody is aggrieved or not is also immaterial. For example, you may say that yes, मेरा गलती हुआ लेकिन किसी का नुकसान नहीं हुआ. That is not acceptable. I'll give you two examples of this. One is that you have signed a balance sheet and it was presented to the bank gave the loan was properly serviced, loan was closed also. That does not mean that if there is any financial misstatement in the financial statement, if there is a flaw, bank can still file a complaint or anybody can still file a complaint. You cannot say that bank has no grievance because the loan was properly squared up. Another example I can give. A charitable trust, if you have audited the charitable trust and the tax impact is nil, it is confirmed that it is an exempt entity. Even in appeal, it is confirmed that it is exempt. Even then, if there is a flaw in the balance sheet or in the financial statement, the income tax department still has a right to complain against you. So remember this, because they are not aggrieved as such, but yes, it is there. Then, as I told you, there is no time limit which now they are bringing. When we studied the amendments, that the broad procedure just now I told you that after the prima facie opinion, there is a hearing. The hearing is given before the Board of Discipline if it is a Schedule 1 offense. Schedule 2 offense, it is a disciplinary committee. Then there you can represent yourself through a counsel. And after going through all your submissions, oral as well as written, the disciplinary committee or the Board of Discipline arrives at a conclusion whether you are finally guilty. And if you are guilty, then you are given one more opportunity as to what punishment should be awarded to you. So and once the punishment is awarded, they pass an order. So there are three things come from the institute. One is prima facie opinion. Second is the report or the findings of the committee or Board of Discipline. And the third is the order. That order is appealable before the appellate authority. So this broadly is the principle or rather procedure. But there are punishments which I told you, there are indirect punishments also. Indirect punishments means basically when you are held prima facie guilty, then that is the stage or that is the point of time where you say that the proceedings are in progress. Proceedings have started. Till that time, when there is only complaint, written statement and rejoinder stage, there is no proceeding against you. But once you are held prima facie guilty, then you are in the empanelment form or even your declaration under Companies Act 139. you have to make, there's a question whether there are any proceedings against the any partner or against the firm. Once you are held prima facie guilty, then you have to mention that yes, the proceedings are there. So that may deprive you of many actually audit assignments and or any other even large professional assignments. So loss of revenue is a big punishment. Actually, these punishments prescribed in the act are sometimes very minor, say 1 lakh rupees fine, 2 lakhs, 5 lakhs, but you may lose revenue of 50 lakhs rupees. So this is very serious thing which one has to be careful about. Then those fines which I have already mentioned. The second punishment is that there is a stigma, because ultimately once you are held guilty, even further 3-4 years you may not get any assignment. So this is another thing, and your name is published in the official gazette. Today, even in the social media, immediately they publicize that this person, this chartered accountant, his name is removed from the register, he is punished, his certificate is or membership is suspended. All these, there are enthusiasts. In fact, there is bad publicity also, because the complainant may circulate it on the social media that such and such chartered accountant is held guilty. So it's a very big blow on your reputation. So these are indirect punishments which I mentioned to you. Then you also do the eligibility. For example, once you are held guilty and you are suspended, then suppose your suspension is for 6 months. After 6 months, when your membership is restored, then it is deemed as if you are a fresh member with zero seniority. That means your eligibility to 10 articles is lost at that time. Your eligibility for handling big audits, bank audits, etc., that also stops. So these are also indirect things, in a part of indirect punishment. And the stigma, as I already mentioned to you. Complainants, who can complain? Anybody can complain. Any Tom, Dick, and Harry, a stranger, anyone can complain. And as I told you, your close relative, director, partner, anybody can complain. Staff members can complain. Complaints may be filed with ego clashes. See, most of the complaints are coming because of the ego is hurt. Now, professional courtesy and etiquettes demand that you behave in a professional manner. Professional behavior is also one of the parts of our good conduct or ethics. So, suppose, for example, you are an auditor of a charitable trust or in a society, and in the society there are many over enthusiastic members. They ask you many questions, and if you ignore them, their ego is hurt. If you write to them that I cannot give this information because of the professional secrecy, because I cannot disclose it to the outsiders, this information you can obtain from the management. If you write to them, this is basic courtesy. So always remember that you have to give a written reply. No oral thing on this. Or if you ignore, then the ego clashes are there, and the institute also then say that you are a professional. See, you have to at least write him once that no, you cannot give this type of information to you or to that person. So this is the professional courtesy, which is also important. And our profession has become very vulnerable today, friends. It has become very humiliating. People are now not uh, giving that much of respect because of our own deeds, because of our own, you can say, uh, lack of diligence, or because of our own negligence. There are 2 or 3 high court decisions which are having direct impact on this. But I'll also explain to you the limitations. As I told you, auditor is a watchdog and not a bloodhound. That is now diluted because of technology, your routine things have been done away with. So you are expected to focus on something creative. And that creative thing means you have to always be proactive with professional skepticism. Unless you have professional skepticism, you cannot do the audit effectively. Peer review is supposed to be a preventive step, but that we don't take it seriously. So peer review, actually, if your lapses are exposed, then that is not basically the foundation or basis of the misconduct case against you, but that gives you an opportunity to improve your ways of working. Well, there are many such things which many such cases that I can share. Uh, even giving a check which gets ultimately bounced or which is dishonored is also a part of your misconduct because it's bringing disrepute to the profession. Of course, it will depend on the facts and circumstances of the case. But otherwise, if you're chartered account and presently there is one complaint which has been referred to me that he was a defaulter in all his loans, that chartered accountant. So even that is bringing disrepute to the profession. Now I may deal with just in 2 3 minutes what is what is a misconduct. Misconduct by section 22 says misconduct means any of the items listed in schedule 1 or schedule 2. There are 34 items and one item has been added now. As I told you in my amendment part of the first part of my speech. So now there are 35 clauses, schedule 1 and schedule 2 put together. If that is there, even the most common complaint is previous auditor's communication. There also, let me clarify that most of the cases are coming on that count. Auditor should communicate in writing with the previous auditor before accepting the audit. What our people do is they just write to them just before the day of signing the balance sheet. Now, even the email communication is permitted provided it is on the email of the member which is appearing on the ICI portal. Or if you have any authentic information about his email ID, then that also is permissible. But email communication is also permitted. Then another aspect of that is that his undisputed audit fees must have been paid. And undisputed audit fees have been defined as the fees appearing as outstanding in the balance sheet, which is signed by the auditee, is deemed to be undisputed audit fee. Now, this is only undisputed audit fee. So, even if there is a fee, professional fee which is outstanding, and if you accept the audit, there is no misconduct per se. Audit fee, if it is outstanding, therefore, when you write to the previous auditor, also it is advisable to ask him whether any of his audit fee has remained unpaid. And you have to verify. You don't have to simply director telling you that we have paid it in cash, or director may show that we have paid and the check by check and the check is also appearing in the bank debited. That is not enough because the previous auditor may say that yes, I have received the amount, but I have appropriated it against my other professional fee like tax work or ROC work or financial services work. Therefore, actual confirmation that audit fee has been paid has to be there. Unfortunately, our chartered accountant, there is no system of issuing receipts of receiving the fees. And therefore, we don't know in what manner that recipient has accounted for it. So, well, friends, there are so many things which I can always share with you, but there are what we need to have is our collective strength, our study circles, our branches. We need to be proactive because whenever the exposure drafts are there, like on tax law or our CA Act or regulations or even standards on accounting, standards on auditing. Now, for example, this revised amendment. Now, whenever it is published as a draft, as an exposure draft, very few study circles or very few branches are such who then study them collectively and then they make their representation. The job of study circles and the branches is that to have a collective strength. Many people are more concerned and obsessed only with the technicalities of GST, TDS, case laws, and other things. But the things which are affecting the very survival of the profession, we are not very serious about. So therefore, I appeal to you and I appeal to all conveners of the branches that there should be a brainstorming session on how the chartered accountants can show their collective strength and how can only then you can follow ethics, friends. Without unity, it is difficult to follow ethics. So all these are interwoven and interdependent things. So I feel that the WIRC or the council, central council also should encourage such type of discussions, such type of brainstorming or such type of sharing of experiences where there are genuine difficulties faced by the profession and how collectively we can solve them. If that is a message I would like to give through this particular opportunity which was given to me, I once again thank Saurabhji Ajmera for this wonderful opportunity to deal both the revised part of the Code of Ethics and the existing Code of Ethics with this very limited time span. I have tried to do utmost justice to that, and I wish all of you a very happy and successful new financial year that is coming. Thank you very much and Jai Hind.
Thank you very much, sir. Any questions, anyone? I don't see any questions, so I'll give the vote of thanks. Good evening, esteemed colleagues. It is my distinct honor to propose the vote of thanks on this occasion today. The session on understanding ethical standards for CAs has been incredibly insightful and enriching for all of us. First and foremost, I extend my heartfelt gratitude to our distinguished speaker, CA Vaze sir. Your expertise and comprehensive delivery on such a crucial topic has provided us with invaluable clarity and practical takeaways. Your insights have undoubtedly enhanced our understanding and will be immensely helpful in our professional practice. Thank you, sir, for your time and for sharing your profound knowledge with us. The examples you gave us will definitely be helpful for us in future. I also like to express my sincere thanks to our Secretary, C.A. Bishan sir, and to our Chairman, C.A. Saurabh Ajmera, for their impeccable role in organizing this session as well as sharing their thoughts on this provoking address at the beginning of the session. A special thank you to our Treasurer, C.A. Rakesh sir. I would also like to acknowledge the efforts of the entire organizing team and the volunteers who worked behind the scenes to make this event possible. Their hard work and dedication is truly appreciated. Finally, thank you all to the participants for your enthusiastic presence and engagement. With that, I conclude the vote of thanks. Thank you very much, everyone. So we have one request in the chat box. Everyone wants the presentation for the evening. So if you could share that with everyone. Yeah.
Yes,
thank you so much.
Okay.
Yes. Thank you very much, sir. Thank you.
Thank you. Thank you.